Sohel Molla. My ID 230125512. Advice for Imaan of rights and remedies under Sale of Goods Act 1979. The Sale of Goods Act 1979 is an act of the UK Parliament which regulated English contract law and UK commercial law in respect of goods that are sold and bought. The Act consolidated the original Sale of Goods Act 1893 and the subsequent legislation, which in turn had codified and consolidated the law. The Act has ensured the rights and remedies of both the buyers and the sellers. Here in this concerned case, Imaan, the owner of Haters City, a small boutique, bought some goods from Tarot's, a well-known clothing warehouse for fabric and other goods. But problem arose when she started applying the goods to satiate her purpose, the white silk. According to Section 13 of Sale of Goods Act 1979, there is an implied term that goods correspond with the description for the sale of goods by description. A sale of goods is not prevented from being a sale by description by reason only that the goods being exposed for sale or hire is selected by the buyer. Here the description given by Imaan didn't correspond with the goods she has got. Imaan informed Atik of the fashion show and asked him for 20 meters of white silk, 10 meters of green silk and 4 meters of black silk. She asked Atik to cut the white silk into 4 equal pieces and green silk into 2 equal pieces. When she opened the bag with the silk, she noticed that the white silk has been cut into 2 pieces and the black silk into 4. It's a clear breach of Section 13 from the part of Tarot's. We can take Arcos Limited versus E.A. Ronason and Son 1933 AC 470 as an example of breach of Section 13 where buyers agreed to buy a quantity of stuffs to make barrels. The contract stated that they were to be half an inch thick. In fact, only about 5% conformed to this requirement, although most were less than 9:16 thick. It was found that as the fact that the goods were commercially within and merchantable under the contract specification and that they were reasonably fit for purpose. But still, it was a breach of Section 13. Lord Atkins said, it was contended that in all commercial contracts, the question was whether there was a substantial compliance with the contract. There must always be some margin, and it is for the tribunal of fact to determine whether the margin is exceeded or not. I cannot agree. If the written contract specifies condition of weight, measurement and the like, those conditions must be complied with. A ton does not mean about a ton or a yard about a yard. It's still less when you descend a minute measurements does half an inch mean about half an inch. If the seller wants a margin, he must, in my experience, does stipulate for it. The sewing machine. There is an implied condition that goods supplied under a contract of sale are of satisfactory quality, except in respect of those defects that have been drawn to the buyer's attention before the contract, or where the buyer elected to examine the goods before the contract. Those defects that the examination undertaken ought to have revealed. The determination of whether or not goods are of satisfactory quality does not depend on asking if the reasonable person would reject such goods. Parliament recognized that reasonable people might decide not to reject goods, even though they did not come up to the standard of satisfactory quality. Imaan chose a sewing machine for £300. Atik informed her that it was discounted and it was an ex-display model. However, it worked well and had no problems. Imaan was happy to purchase as the same one was being sold online for over £1,000. There is an implied term that the goods supplied under the contract are of satisfactory quality, Section 14(2). This replaces the requirement of merchantable quality in the 1893 Act and in the original 1979 Act. The definition of satisfactory quality provided in Section 14(2)(a) seems unhelpful. Goods are of satisfactory quality if they meet the standard that a reasonable person would regard as satisfactory, taking account of any description of the goods, the price if relevant, and all other relevant circumstances. The test involves comparing the state of the goods as delivered with the standard that a reasonable person would find satisfactory, taking into account the description, the price if relevant, and all other relevant circumstances. It is not a test based on whether or not the reasonable person will reject the goods. Section 14(2)(a). The price at which the goods are sold are often relevant in deciding what quality the buyer is entitled to expect. Goods may be of unsatisfactory quality even though the difference between their price and their actual sale value is slight. There was some controversy as to whether the seller's duty to supply merchantable goods implied the goods that continue to be satisfactory for any particular length of time. In Mash and Muller versus Joseph, Emmanuel I, 1961, sellers in Cyprus sold potatoes C and F Liverpool. The potatoes, though sound, when loaded, they were rotten by the time the ship arrived, and was held by Diplock J that the sellers were liable under Section 14(2) on the ground that in such a contract the goods must be loaded in such a state that they could endure the normal journey and be in a merchantable condition on arrival. The House of Lords in Lambert versus Lewis, 1982, confirmed that the implied condition under Section 14(3) of reasonable fitness for purpose is a warranty that goods will continue to be fit for a reasonable length of time. The Court of Appeal in Bartlett versus Sydney Marcus Limited, 1965 CA said that a buyer should realize that when he buys a second-hand car, defects may appear sooner or later, and decided that the car was of merchantable quality. It was held that the buyer's claims could not succeed because the seller made every effort to make it clear to the buyer that the class was defective. Lord Denning, M.R. stated that a buyer should realize that when he buys a second-hand car, defects may appear sooner or later. But the case here is different. Atik informed her that it was discounted and it was an ex-display model. However, it worked well and had no problems. Had no problems is important. That's why Imaan deserved compensation under Section 14. The case of Bartlett versus Sydney Marcus. In the case of Bartlett versus Sydney Marcus, the buyer had been informed of the defect by the seller. The buyer could not claim any rights under Section 14 due to the application of Section 14(2)(c). The needle. There will be a breach of the implied condition in Section 14(3) where the seller sells goods in the course of a business and either the buyer makes known expressly or by implication the purpose or purposes for which the goods were to be used, or it was reasonably foreseeable to the seller that the buyer might use the goods for such purpose or purposes and the goods are not reasonably fit for one of those purposes. Imaan asked Atik to recommend sewing needles that were long-lasting as she would be working with heavily embroidered material. Atik recommended the sharp band needles. At first, Imaan was unsure as she had heard bad reviews of the brand. Atik dismissed her concern and told her that these are the best needles on the market. The particular purpose need not to be mentioned by the buyer, where the goods normally have only one purpose. Press versus Last, 1903. If the goods can be used for several purposes, the buyer must make known to the seller which purpose is intended. Otherwise, the seller will not be in breach if the goods fulfill one of the purposes. Ashington Piggeries Limited versus Christopher, 1972. In Murphy versus Johnson, 2008, it was stated that if the seller knew or ought reasonably to have known that the particular use might create problems, as they would have been obliged to warn the buyer. As Atik didn't warn Imaan, he breached the implied condition in Section 14(3). Thank you.